The Supreme Court of India on 31st January 2023 ruled that armed forces can take action against their officers for adulterous acts as it clarified the landmark 2018 judgment that decriminalized adultery. A constitutional bench of the Supreme Court clarified that its 2018 judgment striking down Section 497 of the Indian Penal Code, which criminalized adultery, will not impact court martial proceedings initiated against personnel serving the armed forces for adulterous conduct. The bench observed in the order that the 2018 judgment in the case Joseph Sain versus Union of India was not at all concerned with the provisions of the Armed Forces Act. The bench further noted that, as per Article 33 of the Constitution, the legislations governing armed forces can provide exemptions from the applicability of the fundamental right. A five-judge bench comprising Justice K.M. Joseph, Ajay Rastogi, Aniruddha Bose, Rishikesh Roy, and C.T. Ravi Kumar passed the order in an application filed by the Union government. The order dictated by the Supreme Court today is as follows. The judgment of this court was concerned only with the validity of Section 497 IPC and Section 198 subsection 2 CRPC. In this case, this court had no occasion to consider the effect of the provisions of the Armed Forces Acts. As we notice, it is not as if this court approved of adultery. The court had found adultery may be a modern problem. This court also held that will continue to be a ground for dissolution of marriage. In view of the fact that the scheme of the acts in the context of Article 33 did not fall for consideration before this court, we must observe and clarify that the judgment of this court was not at all concerned with the effect and provisions of the Armed Forces Acts. This court was neither called upon nor has it ventured to pronounce on effect of Section 45 and Section 63 of the Army Act, as also the corresponding provisions of the Others Act, Navy Act, Air Force Act.